Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello everyone, and welcome to this podcast in the K&L Gates Arbitration World podcast series. My name is Peter Morton, and I'm a partner at K&L Gates in London and one of the practice group coordinators of the firm's International Arbitration Group, and also a member of the firm's Aviation Group. Today we're going to be looking at a development at the intersection of those two sectors, international arbitration and aviation, and in particular the formation of the Hague Court of Arbitration for Aviation, the HCAA, which was formally launched in July 2022 at the Farnborough International Air Show. And I'm delighted to be joined today by Paul Jebely. Paul is the founder and chair of the HCAA. Paul's going to be talking to us about the origins and aims of the institution and some of the key features of arbitration under the HCAA rules. Now, before we get started, I'm just required to note that this podcast is limited in scope as appropriate for a general audience and the applicable time constraints. The podcast is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP or any other entity or individual. So with that introduction, Paul, do you want to kick things off by just giving us an outline of the rationale and main drivers behind the formation of the HCAA?
Sure, Peter, I'm happy to. The story of the HCAA starts with a simple observation by someone at the coalface of the industry from a legal standpoint. Aviation is a global industry with very specific needs, and the existing dispute resolution mechanisms weren't fully equipped to handle them. So aviation disputes are often as complex as the engineering that keeps these aircraft in the air. There's cross-border issues, there's intricate financial arrangements, there's deeply technical questions at the core, and traditional litigation is often too slow, too expensive, too public, and too generic to address these challenges effectively. And at the same time, while many general arbitration institutions are excellent at resolving issues, they aren't, and they weren't specialists in aviation. So that's the gap that we set out to fill. The HCAA was designed and is designed to be the world's go-to forum for resolving aviation contractual disputes, one that combines really the best practices of arbitration and mediation. On the arbitration side, it's enforceability, efficiency, neutrality, with a deep industry-specific understanding of aviation. So it's not just about resolving these disputes, but doing so in a way that respects the unique dynamics of the industry. And one of our big goals is to improve predictability and consistency in outcomes and how aviation contractual disputes are resolved. And over time, as more cases come through the HCAA, we're building a body of arbitration practice that's really tailored to the sector. And that means decisions that will reflect aviation realities, creating a sense of reliability and stability that stakeholders can count on. So in short, we're giving the vast global aviation community a home for resolving its contractual disputes, a home that truly understands it.
Yeah. And I think you touched on this in your initial answer, but often there's a comparison made between arbitration as against court litigation. That's a big topic in itself. But as relevant context, what do you see as the key potential benefits in an aviation context of arbitration as compared to court litigation?
Yeah, it's a great question. There are several reasons why arbitration really shines in the aviation context. And certainly over the past 2 years since our launch, there's been much written and discussed on the topic. But briefly, first and foremost for me is international enforceability. The New York Convention of 1958, with over 170 countries signed on. That means you can, with limited exceptions, readily enforce a properly constituted arbitral award almost anywhere in the world, which is crucial in an industry where parties' assets and operations are spread across borders. Try that in some jurisdictions with a standalone New York or English judgment. And, let me know how you get on. But courts by comparison often face jurisdictional limits that can complicate enforcement. So international enforceability, confidentiality is another big draw. Aviation is competitive. It's a high-stakes industry. No one wants their disputes or sensitive commercial information out there in the open, and in most circumstances. And arbitration proceedings are generally private. That's a major advantage. Others advantages would be flexibility, efficiency. Let's not forget neutrality. Arbitration provides a level playing field, avoiding the perception of a home court bias. And then there's, specialized expertise in some cases, and we can dive into that a bit later when we talk about the Hague CAA. But finally, I would just add, arbitration is generally still less adversarial than litigation, which can help, preserve business relationships. Aviation is an interconnected industry. We all know this because we all see each other at the conferences. Today's adversary might be tomorrow's partner. So maintaining a professional rapport matters, and arbitration better allows disputes to be resolved efficiently and discreetly without necessarily burning bridges. And, certainly mediation does, but focusing on arbitration.
Right. And if we could just turn specifically to the HCAA and its structure, could you give us an outline of how the HCAA is structured? In particular, we'll come to how the Netherlands Arbitration Institute is involved, but could you give us an outline on the structure of the institution?
Yeah, certainly. So at a broad brushstroke level, the Hague CAA, established in 2022, is a foundation under Dutch law. What's important to know right out of the gate is that it is a totally, genuinely nonprofit, while operating entirely independently and impartially. We're not beholden to any industry participant or special interest group. We exist to serve the global aviation industry as a whole. That independence extends to the way that we handle cases. So neither the foundation itself nor its governing bodies, which is the board, the advisory board, and there's 3 standing committees, which are rules, technical, and mediation. None of them play any role in the administration of individual arbitration or mediation. Those are handled entirely by the parties involved and under the judicial supervision of the NAI, the Netherlands Arbitration Institute, which ensures that everything adheres to the highest standards of arbitration and mediation. And I just want to add, because there's some confusion about this, that while the word court is in the name, it's not a governmental body. It's a private, non-governmental initiative. Think of it as a highly specialized service provider. And actually, while we're at it, while it's called the Hague Court of Arbitration for Aviation, and it is seated in The Hague, and the default seat is in The Hague, the Hague CAA's rules are designed to be applied internationally. Parties can choose any seat of arbitration, which allows for flexibility while benefiting from the Hague CAA's expert specialized rules. So a Hague CAA arbitration can be seated in London, Hong Kong, Singapore, Cape Town. You get it.
Great. And just if we can turn to what users can expect in terms of the key features of arbitration under HCAA rules, if you could just elaborate on that.
Sure. So when parties engage the Hague CAA, they're stepping into a process that I like to say designed specifically for aviation by aviation. First up, we offer expedited procedures as our default. So aviation disputes that often can't afford to drag on. So we built in fast track option where awards can be issued within 6 months of the initial case management conference. That's quite unique. We have summary determination mechanisms. Confidentiality is a given. Whether it's proprietary technology or sensitive commercial data, we ensure that everything stays private. Next is our expert arbitrators. Another key feature, many individuals with deep knowledge of aviation and arbitration. So you're not wasting time explaining the basics. Then we have things like our technical standing committee, which is one of a kind in arbitration. We're also leading the way in training and certifying aviation expert arbitrators and mediators. We're transparent about costs, a flexible fee structure, and for urgent situations, we offer robust interim measures, including emergency relief. And, we embrace modern technology, right? From electronic submissions to virtual hearings, we've kind of designed the process to be accessible and efficient as possible.
And question we're sometimes asked is, well, how does this differ from, say, arbitration under ICC or LCIA rules? What differentiates arbitration of an aviation dispute under HCAA rules from arbitration under these, what you might term, so the mainstream arbitration service providers. Any particular thoughts on that?
Yeah, it's a question I'm asked myself as well. Firstly, I should just say here that the mission of the Hague CAA, it goes very well beyond the Hague CAA itself. Our mission, and we chose to accept it, is to promote the use of arbitration and mediation as preferred methods of contractual dispute resolution in the vast global aviation industry, where and how useful to the parties. Our mission is, the main distinction is our exclusive focus on aviation. Other institutions handle a broad range of disputes, but we specialize. Every rule, every neutral, every process is tailored to, aviation's unique needs. The main differentiator, I suppose, is also our close relationship with the industry. We actively engage with stakeholders to ensure our rules and practices remain relevant and effective. And if you see the composition of our core group of about 130 individuals between our board and various standing committees and task forces, that's reflected quite significantly. And then let's not forget our procedural innovations, right? Like the summary determination and expedited processes. These features cater to aviation's fast-paced nature, which is often a critical factor.
And another question, certainly I've been asked, is, well, what if I want to get my aircraft back? You have lessors who are concerned about preserving Cape Town Convention remedies and whose natural leaning is more towards a court process. What comfort can you give those people in terms of elaboration on the interaction of arbitration under HCAA rules with Cape Town remedies and the kind of situation I just described?
Sure. Well, we're looking to address the broad needs of vast global industry, and certainly aircraft repossession is one of them in certain activity areas. So first, interim relief is absolutely essential in aviation disputes, financing or otherwise, and the Hague CAA provides really robust mechanisms to address that need. Our rules allow for tribunal-granted interim measures, so arbitrators can issue orders to preserve assets or secure evidence or prevent actions that might undermine the arbitration or, reduce the value of an asset. We also have an emergency arbitrator provisions. So before a tribunal is even formally constituted, parties can request urgent relief, which is perfect for time-sensitive situations like stopping the sale of an aircraft. If necessary, parties can also seek help from national courts without waiving their arbitration agreement. So that this dual approach ensures that you have access to remedies like injunctions or asset freezes when you need them most. Second, on Cape Town in particular, there's a fair amount of apprehension around this topic, and most of it frankly stems from misunderstanding. Let's start with the clear baseline. Arbitration, particularly in its specialized settings like aviation and the Hague CAA, is not designed to undermine or replace the Cape Town Convention. Very far from it. While there are some nuances and restrictions, the interplay between arbitration and the CTC is less a point of conflict and more a point of opportunity to use each mechanism where it's most effective. Both are essential tools, kind of serving distinct yet overlapping needs. So the CTC is focused on asset-based remedies, things like recovery, repossession, redeployment of the assets, and it's all about providing a rapid, predictable framework for these types of actions. Arbitration, on the other hand, steps in to address rights and disputes that fall outside the scope of the CTC's asset-based remedies. So long and short, and I've written about this previously, when the CTC does not apply or only applies indirectly, arbitration can be a totally invaluable adjunct, filling gap and resolving broader disputes.
Yeah. And I think I've seen there's an updated guidance note issued relating to drafting a clause providing for HCAA arbitration that specifically caters for these concerns with the carve out for Cape Town remedies. Is that right? I think that was issued earlier this year. Is that right?
Yes, indeed. So we have a specific arbitration. I wouldn't call it a model clause. It's part of the guidance under the model clause for such situation.
And again, something that we often hear, particularly from transactional colleagues, is there's a reluctance to be sort of a trailblazer, to refer disputes to what's sort of perceived to be an untested institution. They don't want to be the first. What would be your answer to those concerns?
It's a good question. Someone does have to blaze a trail, and we're doing that. And they certainly wouldn't be the first in incorporating our model clauses or using it to resolve disputes. I guess stepping back, the Hague CAA is relatively new, but its foundation is anything but untested, right? It's backed by the NAI's 75 plus years of experience in administering complex arbitrations and thousands of cases. We benefit from a nearly unparalleled legacy of reliability in arbitration. It's one of the oldest arbitral institutions in the world. The institution's rules, meticulously developed by seasoned arbitration practitioners and aviation experts, really ensuring the highest standards of fairness and precision. And already billions of dollars in aviation contracts have adopted our arbitration and mediation clauses, which reflects the strong and growing industry confidence. This is no experimental venture. It's carefully crafted, rapidly maturing, and it's not going anywhere. I'll go ahead and say that, we've also been referred multiple potential cases, and I can confirm that we have an active caseload. I repeat, we have an active caseload. The fact that no final awards have been rendered yet by the Hague CAA tribunal or any tribunal is not at all a failure. 2 years after launch, facing no less than an industry-wide paradigm shift, it's simply not an accurate measure of our utility or success to say there are no awards that have been issued yet. To leverage this fact as any sort of criticism, in my view, is not, and I've said it before, is not only, intellectually dishonest, but also it perpetuates a fairly common trope that overlooks the complexity of launching a specialized arbitration institution, especially one aiming to revolutionize how the entire global industry resolves aviation disputes. The reality is that the kind of change we're driving, it's a seismic shift in the way the aviation industry approaches arbitration and mediation. It takes time. It's a gradual process, and it's meant to be. Institutions like ours aren't built overnight, and their success isn't measured by how quickly disputes arise by the parties that write it into their contracts or use us for ad hoc, but how effectively they're resolved when they do so.
Yeah. I mean, certainly from an international arbitration practitioner's perspective, picking up the rules, it does contain what many would consider best practice features that you see across the modern arbitration institutions, so that one can see there has been a lot of experience that's gone into the formulation of the rules. So I think people will gain comfort from that. We're just about out of time, but that's been very interesting and informative. We very much appreciate you agreeing to speak with us. Just to flag that we do plan to cover in a future podcast the HCAA's services in relation to mediation. So the HCAA offers not only arbitration services, but also mediation services, and an update to the HCAA's mediation rules is expected imminently, with this podcast being recorded at the end of November. But with that, Paul, thank you very much for joining us, and we'll leave it there. Thank you.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.